believe that's the cue for us to begin, so we'll begin. I'm Bob Bauer. I know you have programs in front of you. I'll be very brief with the introductions here. On my far left is David Pozen, who is a professor of law at Columbia University. He is an author on any number of topics in major journals on constitutional law, and has written specifically on something that will come up in the discussion here today, which is constitutional hardball. He's been a clerk on the U.S. Supreme Court, and like other of our panelists, he has had experience with the Senate Judiciary Committee quite directly. Immediately on his right is Greg Nunziata, who's a partner at Manatt, Phelps in Washington, D.C. He, too, has a very significant Senate Judiciary Committee experience and was general counsel and senior domestic policy advisor to Marco Rubio. On my right is Kristine Lucius, who is the Executive Vice President for Policy at the Leadership Conference. She has many years of experience with the Senate Judiciary Committee as a senior advisor in these matters. In fact, the top legal and policy advisors to Senator Leahy, and is an expert on judicial and executive nominations. And on her right is Russell Wheeler, adjunct professor at American University's Washington College of Law and a fellow at the Brookings Institution's Governance Studies program. He's also the president of the Governance Institute, which has a specific interest in interbranch relations and their policy implications, and has served for a number of years, or did serve as a number of years, as deputy director of the Federal Judicial Center. He's published widely in these areas. The purpose here for me is to stimulate debate, if not hostilities among the panelists. Since we're talking about a broken confirmation process, I thought we could model dysfunction right up here at the table so you could see how it developed. In any event, I thought I would begin because what we're going to encourage each of the panelists, what the panelists and I have agreed, is everyone takes this conversation where they think it's going to be most productive. The broad themes we're going to be looking at is where do we currently stand right now? Where do the grave misunderstandings, divisions lie in our understanding of the advice and consent function of the Senate? What are its sources? How did this come about, if in fact we are agreed that we are in the midst of some significant division, misunderstanding, confusion, if you will, about that function? How did that come about? And last but not least, as always, what is it that we can do about it? And I thought I would begin, this is in lieu of an opening statement, just tossing to each one of these panelists in turn, beginning on the left here with Professor Pozen. I thought I would begin by just bringing up here a few comments that Senator Susan Collins made on the floor of the Senate when she delivered her extensive statement in support of her decision to vote in favor of the confirmation of now Justice Brett Kavanaugh. And I want to pick in particular her framing of what she believes, having been in the Senate many times, having voted on many Supreme Court nominations, what she believed her advice and consent function to be. I could have picked, other members obviously had views expressed over the course of this most recent confirmation hearing, but of course the Collins speech was a somewhat dramatic moment, though I think at that point it was known which way she was going to go, and she went to some lengths to lay out in some detail her views both on that function and also how she decided on the facts of this particular nominee's confirmation, how she decided to apply the standard that she articulated. She takes her cue from Federalist 76, she says, and that the president has broad discretion, that's how she frames it, broad discretion to consider a nominee's philosophy, whereas it is the Senate's duty, she says, to focus on the nominee's qualifications as long as that nominee's philosophy is within, and I'm going to emphasize this, the mainstream of judicial thought. She objects to litmus tests, does not believe that a nominee's personal and political views are relevant areas of inquiry, provided that they can assure her that they will set those aside and simply and judge these cases, set aside their personal preferences and judge cases fairly on the law and constitutional principle. She gives no consideration, she says, and does not believe senators should give any consideration to a president's identity, who the president in office happens to be, or to the political party of the president or of the nominee. The partisan considerations, in other words, in her view, shouldn't in any way come into this decision-making process. And she closes by noting that applying that standard, she voted for all of George Bush's nominees, She voted for all Barack Obama's nominees, and prior to the vote on Brett Kavanaugh, she voted for the confirmation of Justice Neil Gorsuch. That's how she set it out. I don't think, by the way, that the way she set it out is inconsistent with what I understand a lot of members might say, maybe not all of them, but might say about what they believe the standard to be. But let me begin by asking each of the panelists to say whether they believe that, you know, this is an illuminating, adequate statement of what that function is, that it captures how members do think about that obligation, and whether it captures it adequately to our satisfaction. And it's an opportunity to both address that issue sort of as a matter of fact. Do you think that's correct? And if you want, also begin to introduce your views about what may be the shortcoming in it. And I'll begin with you, Professor Pozen.
Okay, thanks very much. I'm honored to be here on this distinguished panel, and also delighted to reconnect with the Brennan Center, where I interned over a decade ago in my youth. I disagree with Senator Collins' statement descriptively and normatively, so I'll say a few words on both. Descriptively, I think her representation of this view that you should just look at qualifications and temperament doesn't actually track Senate practice for a long time now, though it may fairly track her own practice. Before President Bush the first, the rate of Senate non-confirmation of circuit court nominations never went above 20%. That is, 80% or more of circuit court nominations got confirmed under all presidencies prior to Bush. For the last 3 presidencies before Trump, the non-confirmation rate was above 40%. So in recent years, at least, clearly, the Senate has been doing more than just looking into qualifications and temperament, because it's wildly implausible that 40% plus of the Clinton, Obama, and Bush 2 nominees were unqualified. So I think our actual practice is much more ideological than what Collins suggests. On the desirability or not of that practice, I think it's fair and appropriate what she says in her statement about not being partisan, not having partisanship drive your decision to vote to confirm or not to confirm a nominee. The difficulty, of course, is that in our era, partisanship has come to track very closely deeply held, ideological views and political moral views, so that in a world in which there's a tight correlation between partisanship and judicial philosophy, you can't separate those two out, and you're often going to end up acting in a way that looks like a partisan manner if you're sticking with your principled view of how the Constitution should be interpreted. And since at least 1980, you can take the story back to the Nixon administration, but since at least the Reagan administration, the 2 major political parties, as is well known, have not only polarized in their politics and in their voting records, but also in their approach to the Constitution and constitutional interpretation. In a nutshell, Republicans have become heavily associated with the interpretive theory of originalism, with themes of strict constructionism and judicial restraint. And Democrats, by and large, stick to a kind of living constitutionalist approach, which takes into account contemporary needs and values more explicitly. There's a lot of complexity on both sides there, but there are now, there's been constitutional polarization, in other words, not just a partisan or political polarization. And that means that you're going to have more and more situations where Democrats are going to have a constitutional difference with the Republican nominee and vice versa. And finally, I'll just say that in a world in which judges are nominated on the basis of their ideology, that's the world we've been in since the FDR administration. That was really the rise of policy-driven, overtly ideological selection from within the White House. When presidents are doing that, and when the parties have these coherent and very distinctive constitutional approaches, it seems to me that you would just take a qualification or temperament-based approach to your role. It strikes me as close to an abdication of the Senate's responsibility to provide meaningful advice and consent. So that leads to all kinds of pathological outcomes where you get mutual escalation and non-confirmation rates that soar. So I do worry about those dynamics, but it just seems to me strange to think that a senator with a well-developed constitutional view, strongly opposed to the view of the nominee, and again, that is the new normal, that's our new equilibrium, would subside in the face of that kind of deeply held concern about the nominee. So I don't like what Susan Collins did, at a local level as applied to the particular case at hand, but I also think it's an unattractive vision she presents.
Greg?
Thank you. I'm happy to be here as well. I appreciate this opportunity, and I actually agree with much of what Professor Pozen said. I think that Senator Collins' speech was extraordinary. It's worth reading, and I mean, in it, she takes great pains to spell out what tests she thinks the Senate should apply and what the various burdens are. More senators should do that. I think most senators, frankly, arrive at a Supreme Court nomination, certainly, and also likely at Circuit Court nominations, with a decision that's driven by all the kinds of stuff that that the professor was just talking about. And then you see a lot of kind of backwards arguing into justifying the vote that is rarely credible. I think Collins's speech is an accurate reflection of the approach she has taken. And it's basically a belief that senators should defer to the president on these constitutional issues, barring the advice and consent check is just a check maybe on sheer cronyism or unacceptable, unprepared nominations. Senator Graham, who's likely the new chairman of the Judiciary Committee, has also articulated that view, and that's maybe even more remarkable than Collins, because ideologically he's more conservative, and he's also ideologically, in a judicial sense, more firmly in kind of the conservative tradition. There have been senators over time who had that view, that elections have consequences, they should defer to the president's choice. It's a defensible view. I don't think it's commanded by the Constitution or the Federalist Papers or any original understanding. I think the Senate is co-equal, and the Senate should, senators should apply their view of the Constitution and what kind of nominees to the Supreme Court are consistent with that view. But I think in the past, more senators had that. If you look at the debates during the Bork hearings, the Senate appears to be aware that they're applying a much more ideological test than they had been in the past. And there's big extended arguments between both sides, particularly Senator Hatch for the Republicans and then Senator Biden for the Democrats. And Biden kind of makes the case in those arguments that applying an ideological test is something that we can do, but it's kind of in extraordinary circumstances. And he has all these factors that he lays out why the Bork moment was extraordinary, that the court was narrowly divided on important issues, that the White House was motivated to push the judiciary in a particular ideological direction. A lot of the features that he mentions as extraordinary are now kind of just part of the furniture that we're used to. I mean, this is sort of always the situation. So I don't love where we are. I do think it's kind of unavoidable because we have this remarkable partisan polarization and judicial philosophy polarization. I mean, it simply doesn't have to be that if you're a Republican, I probably know what you think about guns and how you believe the Second Amendment should be interpreted. I mean, those are three separate questions that maybe a couple generations ago you might not, your answer might not be predictive of the other, to one might not be predictive of the other two. I do worry about where we are. I think the senators should be more frank about this division rather than kind of resorting to cheap mischaracterizations of cases to score political points. So, Democrats might hit Republican judges for some outcome where a sympathetic plaintiff loses and make it sound sort of cruel and heartless. Republicans might hit Democratic nominees for letting a criminal off as though this person is pro-criminal rather than having ruled in a serious procedural question. We could do with less of that. I don't know how we get there, but we could do with less of that because it doesn't really change the outcome of these votes. The other kind of just note I want to close on in terms of my worries is not just to this vitriol, but I don't know how this functions in the future if we start seeing sustained periods of the White House and the Senate controlled by different parties. It's very hard for me to imagine a Supreme Court nominee getting confirmed today after the Merrick Garland experience, but I think we would have arrived there had that not happened. It's very hard for a member of one political party to vote for the Supreme Court nominee of the other party. I mean, just so many of the questions that divide us sharply as a nation politically are ultimately decided by the Supreme Court. And if you care about whatever your top issue is, you know, if it's civil rights or abortion or guns, these are things that motivate millions of people, millions of voters, and to just give away the question to the other side via the Supreme Court seems inconceivable to me for a senator. So I don't know how the system reacts if we have a sustained period of 1, 2, 3 vacancies.
I should mention before turning to Kristine, when I was in the White House, I heard the phrase, elections have consequences a great deal, typically from senators who came up to both tell me that elections have consequences and also to tell me that they were going to oppose one of the nominees of the president. Kristine.
Were they saying their elections said one thing, but Barack Obama said another?
Apparently.
Bob, I think you're going to have to work harder to get us to disagree, because so far...
I just got started.
Okay. Because so far, I think we're all in agreement that if the test is what Susan Collins laid out, which is deference to the president, and the president gets to consider ideology of the nominee, but the Senate should not, you know, I think we're in a real problem area. I think part of the reason the Constitution has the two political branches both involved in the decision whether to put someone on the Supreme Court or the lower courts is because there's supposed to be a check and a balance. And Susan Collins, the test she lays out, first of all, she herself was complicit in Merrick Garland not being supported. So for her to say that she supported all of the nominees of President Obama, that's just simply not true. I don't recall her once saying anything that Merrick Garland deserved a hearing and a vote when he was pending for almost a year to the Supreme Court. But secondly, I think it's a lot easier for a senator to say that they should defer to the president when the president is of the same party. What I found particularly disappointing and a very difficult to listen to speech was that she did not take into account how extreme this president is. And, you know, we know from her comments she has had real concerns about this particular president. So certainly deference to a president who is as divisive and as controversial as the current one we have, I think was disappointing to many people who had seen Collins before this moment as a potential moderating voice and moderating influence in her party. But I think it would be a mistake to adopt the notion that somehow the president should get deference and be able to look at ideology and the Senate not. But the other thing I do want to push back on is sometimes people talk about the Senate should only look at qualifications. I mean, I think they should look at qualifications, and the minimum professional qualifications are not being met by many of the nominees we're seeing in the last 2 years. The ABA, the American Bar Association, does a professional vet, which is a minimum professional standard. It doesn't go into ideology. Of all judicial nominations nominated to the Article III federal bench. And they have found several recently that are not just not qualified because they haven't practiced for more than 12 years, and many of them have not, but they have found people not qualified for bias. They have found people not qualified for ethical reasons. They have found people not qualified for work ethics. These are really stunning moments that in any previous administration, I believe the person would have been withdrawn. But instead what's happening, because we've gotten to such a low point in the judicial confirmation process, is they just go faster and try and get the person confirmed before the ABA report comes out, or try and get them through their hearing at least before the ABA recommendation comes out. And that is something that even if you're going to have as low a standard as Collins articulates in this speech, then she should not be voting to confirm Stephen Grass to the, I believe it was Kansas to Nebraska circuit, who was found not qualified for bias. So even with her low standard of deference, the president can look at ideology, but the Senate should only look at some narrow views of qualifications. If that's the standard, there are several people who should not have been confirmed over the last 2 years. I think the standard should be higher. I think if people who affiliate with known hate groups should not be confirmed to the bench. People who have clear ideologies that they're trying to achieve on the court, who are clearly political, I think the Senate should take that into account and decide whether that would be a good addition to the branch that's supposed to be apolitical. So I think even her standard, she's not passing, but I think all of us so far agree that it should not be that standard, that low.
Thank you. Professor Wheeler?
Well, in a sense, you've heard everything that needs to be said on this. You just haven't heard from everyone who's here to say it. So, I certainly I don't have much to add to what the other panelists have said, and I agree mostly with it. Several points I think are worth making. One is that this is not happening in a vacuum. This degradation of the confirmation process, which you can date it back, I guess, maybe to the first President Bush, is just part of our polarized politics in a Congress that has trouble doing much of anything, and that shows itself as well in the debates over whether judges should be confirmed. And I should add one other thing. Professor Pozen mentioned this 40% confirmation rate. I suspect that's based on confirmations during the term in which the person was nominated.
I think that's right. It's non-confirmation rate, by the way.
Yeah. Because we have a phenomenon now of renominations, which is back in the Reagan years was just unheard of, but now routinely presidents renominate individuals who don't get any action during the particular term. I think if we pull this out a little more broadly, I think what's going on, and I think it's still going on, in terms of the district courts, which in a sense are the workhorses of the federal judicial system, I think still what's operating is senators of both parties are largely deferring to the president. The number of nay votes for most of even President Trump's district nominations, which the Senate has not been pushing, I should add, the number of nay votes generally has been relatively negligible. I think the change we're seeing is in the courts of appeals, where very few of Trump's nominees get confirmed with less than 40 or so nay votes, and there's a variety of reasons for that. I think Kristine referred to some of them, but that just illustrates that we're in a I wouldn't say a different era, but an era that's just been more intensified, because we have the example of circuit judges who are being confirmed for one reason, and that is because the party of the president is also the party that controls the Senate, and they're just moving those things through with little objections. I mean, there's only one nominee who was withdrawn in all the 40 or so that Trump has put up. Then on the Supreme Court, that's what most of the focus has been on, and there we have, relatively rare instances, but we see what's happening there is again just very different than what was occurring, certainly was occurring, say, 40 or 50 years ago. Before Thurgood Marshall's nomination, the standard way to confirm a Supreme Court justice was by a voice vote. There haven't been any voice votes since Thurgood Marshall, so this process has been intensifying all along. Whether it's a good thing or a bad thing is difficult to say. You could say we see a breakdown of the norms of comity and bipartisanship which manage to staff the courts, or you could say the Senate's finally reasserting its role to actually participate in the process. One final thing, the Senate has confirmed, I think, 29 circuit judges so far under Trump. It's confirmed, and 29 out of not many more that have been nominated so far. It's confirmed about half of the district nominees, and the district nominees, in a sense, that's where in many places, that's where the real crunch comes, because we can talk all we want about ideology and the policy direction of the courts, but it's on the district level that people are either getting justice or they aren't. And when you have vacancy rates in the district court now up around 111, and there's a lot of reasons for that. A lot of it has to do with the failure to act on Obama nominees in the final 2 years of his term. when you have vacancy rates that high, that's really pinching people who just can't get their cases heard, especially civil litigants. And that's an aspect of this process that we pay too little attention to. In Texas, for example, with all the vacancies in the Texas district courts and the Speedy Trial Act preference for trying criminal cases, civil litigants are just left out in the cold. I think in all our talk about the standards for approving Supreme Court justices, we ought to keep in mind also that the whole federal judiciary is an object of attention and deserves more attention.
Greg, did you have a?
Yeah, no, I think we would do really well to think about district courts and appellate and Supreme Courts as two separate categories. The job of a district court is both more vital every day to Americans than the others and less ideological by nature. And that's something that the partisan fights over district judges that have escalated in recent years, I think, is really regrettable. I just wanted to follow up on a couple of disagreements with Kristine, too, is that I think Collins actually did call for a vote on Garland. The objection maybe she didn't actually fight for one, but she did say Garland should get a vote for what that's worth. And on the ABA is just a subject of a big disagreement between the right and left. Generally, I'm on the right side of this. Almost every Republican in Washington views the ABA as an ideological organization. I'm sympathetic to that. Beyond that, I think their professional review is clubby, insular, and bad for the process. So I'm not a fan, and I don't think they're rated very seriously.
But does it trouble you when they find evidence of bias when they're talking with all the local lawyers who work with a potential nominee?
I mean, it troubles me because they don't tell you any of the evidence they're relying on. It's whisper campaigns in local bars, and I've not been convinced by their reviews in terms of in the past from both parties. On top of that, one thing I will say that maybe troubles me, or maybe I could agree with you on a bit, on qualifications of some of the Trump nominees. I think by and large, they've been very qualified. I've been happy. But there's been a few nominations that I wouldn't make, and I think a lot of that is driven by something which Professor Pozen and I were talking about earlier, was this extreme focus on youth and getting the youngest people possible on the bench because it's a lifetime job. And you want that person to either serve in this job as long as possible or be around for a promotion to a higher court. I think in many cases, I just don't think someone in their 30s is really, or in their early 30s is ready to be a district court judge. Or youth on the appellate bench is maybe easier. A very smart law student might be able to do a job of an appellate judge, but a district court judge, no, seriously, a district court judge requires, I think, gravity and experience and the ability to manage a courtroom and deal with witnesses and litigants in a way that 5 years of law practice does not prepare you to do. So I think that's an unfortunate aspect of this process right now.
Can I just ask the panelists I want to push a little bit on the ABA's role here for a second. First of all, I wouldn't say that I share the strongest objection that Greg just articulated, but there's less space between him as a Republican and me as a Democrat on the ABA's role than you might think. I definitely have some sympathy for the view that it's clubby. And I also wonder if we're not going to, it currently operates very much in conjunction with or in support of, at least for the presidents, unlike, say, George Bush, who had ABA review prior to nominating the judge. It tends to shore up the presidential's claim to deference, doesn't it? Because then the presidents say, well, I can't imagine why in the world you would turn down this nominee who's been rated well qualified by the American Bar Association. If we were to see a frank acknowledgement that the deference standard has been at best overstated and perhaps is obsolete, wouldn't that suggest that the ABA role ought to be at least minimized, if not potentially an argument made that it shouldn't have the visible role that it's had in the past?
I don't doubt that it's clubby. It is clubby. It tends to favor law firm lawyers. And it frankly tends to favor white lawyers. I think there have been some important studies about how it, some bias there, but it is incredibly unusual for them to vote unanimously not qualified for several judges on the kinds of issues that several Trump nominees have had recently. Now, you're right that in the Clinton administration and the Obama administration, the ABA process happened before someone was publicly nominated. So that if you as White House counsel got a bad report that this person's found unanimously not qualified for work ethic, I would imagine that would factor into the decision whether to nominate that person. Whereas President Bush and President Trump have that process happening after the person has been nominated. So it's a lot tougher for that person then to withdraw without looking like they're validating the assessment. So if we are going to talk about ideal norms, it is better to have that process earlier. Or if we could come up with a different person who would do, a different entity that would do a minimum threshold professionalism reputation check. But Republicans cling to the rating if they like it, and they ignore it if it's clearly disqualifying. And that's the biggest problem I have.
Yeah. And when I was Chief Nominations Counsel, when Senator Specter was chairman, and we had asked the ABA had a couple of unqualified ratings on 2 nominees at the time. I think one was a circuit court in the South, and one was an African-American woman who was nominated to be a district court judge in Connecticut. And their top-line conclusions were concerning, and we wanted to know why. Can you share with us this information? I forgot what it was. It was if it was bias or lack of experience or lack of professionalism. And we said, can you tell us the basis of this decision so the Senate can make up its mind? They said, no, it's a confidential process. You can't peer into what we do. It has to be confidential. We said, well, we get the FBI files on people with very sensitive information. We handle it like it's top secret. Can we do it in that way? So just the Senate can know. I mean, if this is true, we should be concerned. And their answer was no. You have to trust us. And I just don't think the ABA has earned that trust, or that any outside organization deserves that trust.
So let me just, before we sort of move away from the question of deference, I just wanted to ask the question of any panelists who would like to weigh in on it. At some point, this was, as you say, whether in the guise of elections have consequences or whatever, the deference standard was upheld. And now, there's obviously, it seems on this panel, agreement that it's not the correct standard. Some people have attributed this to a polarized politics generally, or to shocks to the system, like, for example, the Republicans would say, or the way the Democrats treated Robert Bork. And the Bork nomination was the beginning of the spiraling downward into the arrangement we currently have, or excuse me, not the arrangement because it's not an arrangement, but the situation we currently have in which deference is clearly not paid, even if lip service is paid to it, and it's a power struggle. Professor Wheeler, I guess I'll turn to you first, because I know that you've expressed in some of our earlier sort of preparations for the panel that you don't buy the historical analysis that there was a sort of historical shock to the system in Bork and that it changed everything. And I thought it might be illuminating to hear why you think that's the case.
Well, as a general principle, I tend to be skeptical of any argument that, but for a certain incident, the landscape would look a lot different. I mean, but for the Bork nomination, the Senate Judiciary Committee would be sitting around, singing Kumbaya to each other. Well, as I said earlier, what we're seeing is a slow accretion, a change in norms, a change in practices due to the greater polarization in all aspects of our politics. The Bork nomination, which was ugly in all sorts of things, was perhaps a representation of that change, a particularly vivid representation of that change. But I don't think had Ronald Reagan nominated Anthony Kennedy at the start of things, that the situation today would be much different. He nominated Bork, and then of course he lost the Ginsburg non-nomination and finally nominated Kennedy, who got confirmed fairly quickly. But, well, I'll just repeat what I said before. Just because the Bork thing was contentious doesn't mean that it caused the contention we're dealing with now. If it did anything, it may have been a slight catalyst, but I don't think it could be regarded as anything more.
Any different views from anybody else in the panel? We're not looking to signal historical events.
I think it's hard to tease out the causal significance of Bork. It was, as Professor Wheeler suggests, I think symptom and cause of the escalation that would follow. But I guess I agree with the bottom line that whatever had happened with Bork, likely we would have seen this pattern of both sides becoming less likely to confirm the other side's nominees just as a function of increasing polarizations. There's a great deal of political science evidence that the parties start to polarize in a big way around roughly 1980. The polarization has been asymmetric in the sense that Republicans have moved further to the right than Democrats have moved to the left. But under those background conditions, you were, I think, going to see mutual escalation of hardball in judicial confirmation politics. I do think that in judicial confirmation politics, as in other areas of congressional practice, Republicans have played harder hardball on balance. But the discrepancy between Republican hardball and Democratic hardball, I actually think has been less when it comes to judges than in other areas like government shutdown politics or debt ceiling brinkmanship, voting, issues around voting and enfranchisement. So I think it has been a pattern of mutual escalation. You have seen Senate Democrats being the aggressors in certain areas, innovating with, say, the filibusters of the second President Bush's first-term circuit court nominees like Miguel Estrada, Senator Harry Reid pioneering kind of pro forma gavel-in, gavel-out sessions to block some nominees of the second Bush term, and Republicans have done a lot of things that I could characterize as hardball, most obviously, and recently the Merrick Garland refusal to give him a consideration. But anyway, I do see this as flowing out of the background conditions of increasing polarization, asymmetric polarization. I just might add that given the consensus that was developing on the panel, you can see the bind we're in, because everyone seemed to say senators shouldn't be doormats, right? They have a meaningful constitutional role to play in reviewing judicial nominees, particularly Supreme Court nominees, given that Supreme Court is a kind of super legislature, touches on so many issues Americans care about. And therefore, as non-doormats, senators should oppose nominees whose jurisprudence they think would deeply disserve the country and the Constitution. And given polarization, that's going to happen with greater and greater frequency across the parties, that kind of belief. And I'll go further and say, and senators will oppose those nominees. They may do it through a sublimated language of qualifications and a technocratic language of like the ABAs, when really their concerns are deeper and more about the jurisprudence. But and then given that polarization and given divided government that we're often going to have, we've reached a point of impasse where we really have profound dysfunction in how the confirmation process is likely to play out in the foreseeable future. So I'm happy to talk about where we might go, but I just want to mark that the analysis, the diagnosis provided by pretty much everyone on the panel suggests a truly pathological equilibrium that we're now at.
Can I just add that I think there's a big, I can't point to one area, one example in the past that I think started it all, but I think there's a really big difference between a fight, a transparent and public fight over where a nominee wants to take the law or his or her qualifications or his or her fitness to be an impartial judge versus the non-transparent kind of systemic power plays that we've seen. So I would put the Bork fight in that first bucket, which is there was a good public discussion. More people got to understand who this man was, what role he played in the Saturday Night Massacre, what he had written about where he wanted to take the law. And it was clear he had a real agenda, was not just going to sit dispassionately. And I think that both Kennedy's Bork's America speech, but also the hearings were a real public examination of what that meant. Put that in the first bucket. In the second bucket, though, you have people like Chairman Hatch who, in a non-transparent way, stopped more than 60 Clinton nominees from even getting a hearing, even seeing the light of day. And to me, those are much more the power plays that don't get enough attention. Elena Kagan was one of them. Elena Kagan was nominated to the DC Circuit, never got a hearing, never got a committee vote, obviously never got a floor vote. Luckily for her, it worked out just fine in a later administration. But the point is, there are these systemic, not on the nominee's merit fights, which I think don't get enough attention, but have been more impactful than the handful of Bush nominees who were filibustered to the circuit courts. I mean, we're talking about 12 to 15 of those, but we're talking about more than 60 in the non-transparent, the chairman just never scheduled for a hearing, never advanced nominees. And blue slips can fall into one or two of those two buckets, but my point is that I think there are public moments where people are actually paying attention. That tends to only be the Supreme Court. But the real power plays are these not based on an individual nominee's fitness. They are based just on the struggle. So refusing to move Obama nominees for the last 2 years of his presidency because Chairman Grassley had gotten the gavel and Mitch McConnell wanted to hold open vacancies for the next president, whether that was Supreme Court, but it was all on the way down. I mean, Chairman Grassley held hearings for 5 circuit court nominees in 1 month last year. That is the same number of circuit court nominees who got a hearing in the last 2 years of Obama's term in office, right? So it's those things that get very little attention, but that's where I see the power plays, and frankly, Republicans just much more aggressive in that power play, is not the fight over an individual's fitness, which is out in the public hearings, discussion about it, frankly, want more people to care about those things. But there are these behind-the-scenes systemic things that don't get enough attention but are really corrosive.
Look, I mean, I think it's completely a good point that we should think about these things in different categories. I just want to point out, as the Republican up here, that this is not a partisan problem. I don't think Republicans have been more aggressive in this category. The Deputy Attorney General of the United States is not on the Fourth Circuit because the Democratic senators from Maryland said he was just too good of a U.S. attorney and they wouldn't allow him to have a hearing for the Fourth Circuit. No hearing, no vote. With senators who conceded that he was a great person. Peter Keisler, who was acting Attorney General in the Bush administration, he's getting great press today for taking a stand against the Trump administration, is not on the D.C. Circuit because he didn't get a hearing or process from Senator Leahy in the last 2 years of the Bush administration. This stuff happens a lot. I don't have the stats on who does it more. I suspect it's pretty even. Maybe the trend lines are just getting worse. I think I agree that it's unfortunate. I don't know how to handle the problem, but it's different.
Professor Wheeler?
Just one thing. I think that's true. You can pick all sorts of examples of what some people would say unfair treatment. What strikes me, though, are the bigger changes, which suggest that both parties are giving very little consideration to what comes next. I mean, the Democrats ended the filibuster for circuit and district court nominees and are now stuck with that. And of course, the more recently applied to the Supreme Court, are now just stuck with that change. Now, I think they had good reason to cut back on the filibuster. We can go into that if you want. But there's very little consideration anymore of what happens next. And then the other example is really clear. Basically, the Republican Senate in 2015-16 just shut down the nomination process. There was Merrick Garland and there was Garland 2.0. 18 district judges, 2 circuit judges confirmed in that period, which is very different than lame duck senates under Reagan, Clinton, George W. Bush in the final 2 years of their 8-year terms. What now everybody's wrestling with is, what happens when the Democrats are in control of the Senate and the Republicans in control of the White House? And I'll tell you what's going to happen. There's not going to be any confirmations. They're just going to stop. But by doing what they did, with all due deference to McConnell and Grassley, doing what they did, they just set themselves up for a situation in which payback comes along, and it just further deteriorates the process. And I don't know what's going to fix it, I got to say.
I mean, no, this is all a one-way ratchet. It's just about who uses a certain tool first, right? I mean, when the Democrats started filibustering President Bush's judges, that guaranteed that Republicans would start filibustering President Obama's judges. And there's just, we can talk about what kind of system we'd like, but it's very hard to get a member of either party to believe that refraining from some tool will earn you goodwill from the opposite party, and they will also refrain from using that tool when it advantages them. It's hard to do that. I worked for a while for Senator Thune, who's now the whip, and he's maybe the only senator who ever got elected largely over nominations debates, and particularly the issue of the filibuster. And he, too, found himself eventually voting for filibusters of Obama judges under essentially this argument. This is, you may not have liked it, you may have thought it was wrong that Democrats started it, but that's where we are now, and you can't turn the dial back.
Yes, I want to turn now to the reform, the question of what you do about all this, because as Professor Pozen said, you know, so what happens next? Before I do, I did want to make one observation, which is that when we've been drawing distinctions here between Supreme Court and appellate nominations on one hand and district court nominations on the other, and I think that's particularly important when you talk about what role the Senate thinks it has. In my experience, senators believe that they have a major, if not overwhelming stake in the district court nominations and a say in those nominations. And frequently they will not move on any nomination they themselves have not dictated, whether it's emerged from some sort of sorting out process within the state, or whether it's simply an agreement within the delegation, or sometimes even worse, nothing happens because the delegation cannot agree, right. And then each side is yelling at the White House for not giving the participants to the dispute, to the combat, their wish. And some of that proprietary behavior on the part of senators has started to leach into the appellate court field. I certainly saw in the White House members who were starting to make the same noises about the imperatives of having their political interests respected in appellate court nominations, much like I heard it in the district court sphere. So I just wanted to mention that because there's another institutional struggle there as well. But
can I just mention
sure.
on that? But Senator Grassley completely changed the blue slip rules for circuit court nominees. He's now moved circuit court nominee after circuit court nominee over the objection of both home state senators.
That's correct.
So that even if it was starting to, you know, in your words, you know, creep into the appellate level, that's gone now because Senator Grassley, although he abided by blue slip restrictions of not getting hearings when Obama was president, he completely changed course once Trump took office. And
I'll just say that's true. I think it's possible that respecting the blue slip, the blue slip process may come back in some modified form into vogue just because the political interests on the part of members are so powerful. Mm-hmm. But we'll see. And certainly at the appellate court level, it's imperative. By the way, blue slip referring to if any home state senator says, hey, that's my call, they just won't so-called return the blue slip and the nomination will not go forward if that process is respected by the leadership of the Senate. And that's been laid aside, as Kristine just said. Let's go to reform. I'm going to start on the left here with Professor Pozen. I'd like you to talk a little bit about what are the different ways that we break the stalemate? What are the avenues? And then go through panelist by panelist. What thought do you have if this current arrangement is just fundamentally unsustainable, but we're operating in a polarized environment which makes the path to a solution seem very unclear? Where might we go?
Thanks. So there are two kind of pie-in-the-sky solutions that seem to be in circulation, and I think they're related, and I have a preference for one. So the first way out of the stalemate might be to ratchet up hardball even further and engage in court packing at a time when a party, I'm thinking particularly the Democratic Party, had sufficient power in Congress and held the presidency and could do that. So there's been a lot of calls for court packing. Probably everyone in this room has heard some of those calls since the Kavanaugh confirmation. I'm sympathetic to the impulse. As Kristine says, there's a very plausible story that there's been hardball on the Republican side in recent years, and the Garland seat being the most obvious recent example. But more generally, the Supreme Court a majority of the Supreme Court has been appointed by a Republican president, a majority of the justices, since May 1969. We're about to hit 50 years of the Supreme Court having a majority of the justices appointed by a Republican president in a period in which there have been 5 Democratic presidential terms served. The Senate has been controlled by Democrats more than half of that period. Democratic presidential candidates run a majority or plurality of the presidential vote in 6 of the last 7 elections. I could go on. There's a profound mismatch between the ideological and partisan composition of the court and the actual politics of the country, and Democrats have been on the losing end of that for years. So it's a dismaying situation if you identify as a Democrat. Court packing, however, this is the proposition that should Democrats, say, control Congress and the presidency in 2020, they would add 2 new seats to the Supreme Court and fill them, of course, with Democratic justices, and in this way rectify this imbalance. But as Greg was suggesting, once a tool is used, it can be hard to contain it. Court packing, of course, could be used by the other side in a future period. It comes with a bit of a historical taint, given the failure of FDR's effort in the 1930s. It is worrisome from a judicial independence perspective. It's a dangerous game to play, court packing, although, again, I strongly sympathize with the impulse here. So that's like taking hardball further. That's one way out of our impasse, at least with regard to the Supreme Court. The other kind of opposed way, which I've called in some writing the anti-hardball solution, would be to change the judicial nominations system altogether in a way that's meant to de-escalate the politics. What would that possibly look like? I think it would look like what most of the rest of the world does, which is not life tenure for Supreme Court justices, which creates all kinds of bad dynamics. Justices get to time their own retirements, so that a sympathetic president can appoint their successor. There's an incentive to appoint really young judges and justices because you want them to stay on as long as possible. There's just arbitrariness. Jimmy Carter not getting one Supreme Court pick in his presidency is still a disaster we're living with, for Democrats, and that was just the luck or bad luck of the draw. And the fact that someone has life tenure, of course, just increases the stakes of any given confirmation fight and makes it this blood battle that we've been describing. So there are a lot of proposals that have been out there for a long time by academics on the right and the left. A common one would have the justices get 18-year terms. Each president serving a 4-year term would get 2 picks, and then to comport with the Constitution's guarantee that you hold your job as an Article III judge during good behavior. You would transition. You wouldn't get kicked off the bench after 18 years. You transition into some sort of senior status. There are a lot of different variants on this proposal. There is a debate about whether it would be consistent with the good behavior clause of Article III, Section 1, and also with the appointments clause. If you're transitioning off the Supreme Court, would you need a separate appointment from the president or not is a tough constitutional question. But it's at least plausible that a statute could be designed consistent with those 2 constitutional provisions that would move us away from life tenure toward a fixed term on the Supreme Court. And that would, I think, lower the temperature on a lot of these debates and potentially get us to a healthier place. Okay, last quick comment is of course, how would we ever get there? How would we, given our fractious politics, how would we ever get to this kind of good government solution, which I do think a designer would opt for, in the first instance. I don't think anyone would choose our life tenure system if they were designing, a judicial confirmation process from the scratch. And evidence of that is that the rest of the world doesn't do it. They've learned a negative lesson from us. Okay, so how do we get there? Well, there I think court packing in a kind of paradoxical way may come back in. It may be that there has to be a credible enough threat of the hardball option of court packing to get both sides to the bargaining table and actually get any momentum around these bills, which have been out there for years, to move to 18-year terms or some variant thereon. So I think the best case for court packing is if it could change the bargaining dynamics around breaking out of our current system altogether. In any given period, whoever controls power doesn't want to change the procedural status quo. But if Republicans really feared that Democrats were rising and might actually pack the court, maybe there'd be the possibility of a deal to be struck. And by the way, you could phase this in, the 18-year proposal, so that it doesn't take effect immediately in case there were concerns about that so-called sunrise approach. So have it take effect in a future period in which we can't know who the president will be. It's really not a question of design. There are, again, these kind of well thought out proposals been around for a long time. It's how could we ever get the politics to accommodate this seeming on the wall? And I wonder if court packing rhetoric, court packing threats has a role to play there, much as I worry about court packing.
Greg?
Thank you. It's really thoughtful as usual. Just a couple quick notes on what the professor said. First, it's true that Republicans have had the benefit of the calendar and appointed more Supreme Court justices over the last 50 years. Republicans have also been much less lucky in having their nominees perform as they had hoped as things go forward. I mean, I can't think of a high-profile, ideologically divisive case in which a Democratic nominee disappointed the left that's occurred since maybe Roe versus Wade, and this has happened a lot on the Republican side. Just sort of interesting. We could speculate why. No, the rest of the world doesn't model their judiciary on ours. Remarkably, or their selection process. Remarkably, neither do the states. New Jersey is the only state that follows the federal model out of all 50. I don't know that that's definitive. I mean, I think our federal judiciary is actually pretty impressive, and maybe more impressive than a lot of the state and foreign judiciaries, but that is what it is. On the proposal of termed justice terms for the justices, I'm open to it. I'm not sure that I'm convinced that it does more than take down the temperature a notch. I don't know if it's transformative. I think that fundamentally the problem still is that the federal government does too much, and the Supreme Court or the judiciary is involved in too many areas that really should be resolved by the political process. And so long as that's true, I think these fights are going to be ugly, just maybe better scheduled. Which points to a couple of things I might say. One, I do think it would be helpful to cleave out the district courts, and the Senate could have some rules that would have guaranteed judicial court nominees would move on a better calendar and get votes more quickly. That I think would be helpful just to litigants in our country. But to solving the Supreme Court problem, one other idea that's out there that some on the left and the right have talked about, which is I'm not necessarily endorsing but interesting to think about, is jurisdiction stripping. Is the right and the left coming together and talking about areas the court's involved with that they don't like, and the court's playing a counter-majoritarian role, and you could pair issues like this on the left and the right and come to agreements that we're going to, the court's not going to be the last word on abortion anymore. It's also not going to be the last word on campaign finance. Those are probably not equally weighted issues, but this sort of idea. And that's starting to bubble up in the academic world now, and it could be something that becomes part of our political conversation. I mean, again, if the real problem is that we're just so divided on these issues that the court is involved with, maybe take the court out of that. I mean, they really are a small percentage of cases that the Supreme Court rules on every year.
Kristine?
Wow, that scared me. Jurisdiction stripping, the history of it in this country, at least the most recent jurisdiction stripping attempts in the Senate. I remember Senator Leahy would often tell me the story about how it's one of the few things that he and Barry Goldwater agreed on, full stop, was fighting Jesse Helms and Strom Thurmond, who tried to strip court jurisdiction from desegregating schools. So it's got a really ugly history,
Sure.
And so the notion that someone's civil rights, shouldn't be determined by an independent court, but instead should just be determined, in the political branches. I think that's wow, that makes me nervous.
I mean, it's a conversation that's out there, as I'm just pointing to.
The selection process needs to be fixed. So, the pre-nomination process. So one thing I will say is I think it's going to get worse before it gets better. And maybe we're headed to a Watergate situation in our democracy. We are clearly headed to a Mueller versus Whitaker crisis. And maybe in the wake of that crisis, there will be some rethinking about the importance of protecting our democracies and importance of protecting our institutions, especially ones that hold accountable a president who tries to tear them all down. So I think it's frankly going to get worse before it gets better, and there will need to be a reform movement that isn't just looking at the courts, but is instead looking at all the democracy-preserving things that serve as a check on an individual president. So you might see those types of things, but I really think that the selection process could use some reforming. So to the extent that it's senators choosing their college roommate, that's a problem. If there were better in-state, closer to the communities, commissions, and some states do have commissions. Wisconsin long had one that was a bipartisan commission, and it recently got hijacked, and now it doesn't serve the role that it served for all the years that Senator Feingold and Senator Cole abided by it during both the Bush administration and the Obama administration. But you could have better process so people have more faith that, at least for district court nominees, that you are really getting someone who is of the state, is a moderate, is not trying to bring a political agenda to the bench, then that might be a way to bring the temperature down. But that will only work if senators recognize their institutional interests. And that's what blue slips were. It was senators realizing that if I let President Obama, run over me, how am I gonna, who else around here in the Senate can I get to fight on my side that might be of his same party that could influence it? So the blue slip, the demanding that home state senators have a very active role, especially in the district court level, had a lot to do with the Senate asserting itself, its institutional role. That is gone. That is, over the last 2 years, that has been eviscerated by Senator Grassley. Maybe if Lindsey Graham takes over the gavel, he will re-implement that. But it really is the chair of the Senate Judiciary Committee who could dial down the temperature, could help by reinstituting that so that there wasn't as much fighting, at least at the district court level.
Professor Wheeler?
I am reminded of an observation of the former dean of this law school, Arthur Vanderbilt, who said, later the Chief Justice of New Jersey, who said, judicial reform is no sport for the short-winded. And you think back, well, my bottom line is I don't think this thing is going to get fixed until both parties realize it's in their interest, that they're getting more damaged by the situation than they are benefiting from it. And I don't think we're anywhere close to that situation yet. I think, for example, shortly after the Civil War, it was pretty obvious that the federal judicial system was not operating in any sort of a decent way. You had mandatory jurisdiction in the Supreme Court, no intermediate courts of appeals, the district courts, which were in courts of last resort in more ways than one, and a Supreme Court that was heavily backlogged. It took 25 years to fix that, even though everybody realized that something had to be done, but there were interests operating underneath the surface that just prevented anything from happening. I think the same thing is true here. I'm intrigued by many of the suggestions that were just made. I don't think, by the way, that these vetting committees, I've looked at them and I can't find any impact that they have on time to nomination or quality of nomination, but that's a different matter. But some of these fundamental changes, for example, the suggestion that we threaten term limits as a way of encouraging just a toning down of the process, that might work. But I don't think, as I said, I just don't think anything's going to work until both parties look at this and say, we just can't keep on going like this. It's just doing too much damage to us in all sorts of ways. Put aside the public interest, our own interest as Republicans and Democrats. We just don't perceive this as positive anymore, and I don't think we're anywhere close to that. And on that happy note.
Yes. So the panel has not been hostile, it's been gloomy. We'll go to, I think, questions at this point. And I think, is there a microphone? Yeah, there are microphones on both sides.
Yes, we have microphones on both sides for anyone who would like to start to line up.
Hi, I think it was Mr. Nunziata who said that he thought that a lot of judicial decisions should be left to the political process rather than being decided in the judiciary. I and a generation of people I grew up with went to law school because of Thurgood Marshall and Brown versus Board of Education. I'm from Baltimore. Thurgood Marshall lived in my neighborhood. I knew him. And I could tell, I worked at the NAACP Legal Defense Fund one summer. He came up, took us out to lunch, and just regaled us with stories about appearing before district court judges in Alabama and Mississippi. But he told us that the one thing that he always knew was that if he got to Washington, somehow what happened in the Court of Appeals in Arkansas or Atlanta didn't matter anymore. And he did this when he was arguing and not when he was sitting. So I think until we actually get to, do you think that the problem we're having is more that we become a divided country politically? People I was in law school with told me that they predicted a day when the Federalist Society would actually get to a point of sending a president Court of Appeals nominees in their 30s and 40s who had written a lot of things who you could not predict, or you could predict, would not probably change as they got older. I think that's where we are right now. But the question is, do you think that you can fix the judiciary? And when this Constitution was drafted, no one thought that a lifetime appointment didn't mean 40 years on the Supreme Court or 40 years on the circuit court. It meant a person was probably going to not be around that long. But now we're looking at people who have been asked, how do you feel about gun control? How do you feel about Roe when they're 40 years old? And that's the person that you want nominated because you want that to go on forever, even after we're gone. So can we fix this without changing us as a country? Thank you.
Thank you. I'm pessimistic about all of this, right? Yes, I think a lot of these problems stem from how divided we are as a country on a range of issues. And I think there are other systemic problems here, such as, I think, Congress retreating from its role and deferring to the courts far too often. So I don't have a solution. And I wasn't suggesting that jurisdiction stripping is the solution. I was suggesting that it's something that's going to become more and more a part of the conversation, particularly if we do have a judiciary that it becomes more and more right-leaning when the popular vote becomes more and more left-leaning. And you have thoughts on that issue too, I know.
I'll just say briefly, I don't think jurisdiction stripping should be categorically off the table, although maybe in certain rights areas it should be. But in general, as a general proposition, I think it's plausible. There's clear congressional authority. There are ways it might be done that would allay the civil rights concerns and have a salutary effect, although the history there, it doesn't give great reason for optimism. But you also made a point about longer terms that are being served. I have just a little data on that from a study published a few years ago, finding that between 1789 and 1970, the average Supreme Court justice's term was under 15 years, 1-5. Since 1970, it's been over 26 years, average tenure. So it's a not just a quantitative, but arguably a qualitative shift in what it means to get a Supreme Court appointment when you're serving nearly 30 years. And I think in a democracy to have that lack of turnover is troubling in itself.
Any, Kristine or Professor Wheeler, any thoughts?
No.
Okay. Sir, please.
Yeah. So I probably should tell you who I am. I'm Steve Sussman from Houston, Texas. For 8 years, I served as the chair of the American Constitution Society Judicial Nomination Task Force. And for about half that time, or maybe longer even, I have been a member of the Judicial Nominations Evaluation Committee of the 2 Republican senators in Texas. I am indeed probably the remaining show Democrat and plaintiff's lawyer on that committee. It is amazing how a good group of lawyers around a table, whether they're Republican or Democrat, can come to a consensus on who is the best qualified to be a trial judge. And we do it, and thus far, the senators, we have a dispute between our senators, in a way, and the dispute that's going on, which I think is now broken out in the public, is whether a trial judge should know about how to try a case, or whether it's okay for a judge to be appointed a United States district judge who has never seen a jury trial, never conducted a jury trial, and we have some of those now that are being recommended by the White House and the Senate, and there's a dispute whether that should be done. And when it is done, it alarms the Republican lawyers on this committee as much as it does me, the Democrat. So here's some things that you can do and need to be done by academics in the Brennan Center. You should come up with a model process for senators to use when they appoint committees to advise them. In our process, which is the process I feel free to talk about, which is the senators announced that applications are open. And anyone who wants to apply fills out this impossible application, 50 pages long. So one of the things you ought to do is come up with a model application that has the crucial material that can be gotten to quick. How do you appoint members of the committee? Should it be balanced between Republicans and Democrats? Obviously it should be. And I think you could get even Republican senators and Democratic senators to agree on that change. That good lawyers, practicing lawyers in the community, you put 4 Democrats and 4 Democrats, or 40 Democrat, 4 Democrat, whatever the number is, you evenly divide it. One of the reasons that works, the process works, is that it is confidential. And even though I am not a supporter of the senators who appointed me to the committee, I would never tell you what goes on in a committee meeting, because I am sworn to secrecy, and it's done in private. One of the things that could be done would be a recommendation that the hearing process be a private process. There's nothing that requires that process to be public. In Israel, when they appoint judges to the Israeli Supreme Court, and they are a society very much like us, torn by very much similar issues, they don't have anything like the Kavanaugh hearings or the hearings we've been through, because they are private. There's a committee of lawyers and judges, members of the Knesset, that makes recommendations, but those hearings are all confidential. So why do you have to have these hearings public? They could, I think the senators meet periodically on highly sensitive material. The public cameras are not allowed in the room. It's become a television event. And of course it's going to become politicized as long as it's publicized. So that can be changed. And maybe good Democrats and Republicans would agree that that's a change that should be made. But then you tell them how to appoint committees. You have a model application form. You tell them about how those committees ought to vote. Should it be a public vote? Should they vote secret ballot? Should the vote be announced? What the timing of everything? Rules, because otherwise the senators don't have anything to go by. And they do the best they can. And the one who's most interested, if there are 2 senators, the one who's most interested in Texas, I think there's no question that Senator Cruz is the most interested in putting people like Senator Cruz. And these people are, you can see them coming from a distance. They clerk for Scalia, Thomas, or Alito. They are totally qualified, except they've never tried a case, they have never seen a trial, they don't know what motion in limine is, they don't know what voir dire is, or a Daubert motion is. These are things that are foreign to them. And they are now being dispatched to small towns in Texas, which have a single federal judge. They have never, a lot of carpetbagging, that's another thing you could make recommendations on. Should we be appointing district judges to go to a town where they've never lived? Someone who's worked for an institute in Washington who clerked for the Supreme Court, what business do they have being on the trial bench in Lubbock, Texas, or Midland, Texas? And these are questions that we discuss in our committee, by the way. And it would be helpful to have some model recommendations. Get 10 law professors, 5 Republicans, 5 Democrats. Get the Brennan Center to sponsor this. And begin with the lowest court, the trial court. Because what these 30-year-olds that are getting on the trial court are going to be, they're the next appointees to the Fifth Circuit and the next nominees to the Supreme Court. So, you can see what's happening.
Sure. Thank you very much. That's very helpful. And I don't know that such a model process exists. I don't know that I've ever seen one, or that anybody has actually sketched one out. So that would be actually a very useful project. Yes, sir.
Yeah, this is a question for Professor Pozen, but I would welcome anyone's thoughts on this. To your proposal about term limits, I guess the question I have, aside from the constitutional issues of appointments clause or for cause issues, is what would you do about the revolving door problem? I mean, for the most part, we've had federal judges who don't go back into private practice. If you had a term limit for Supreme Court justices, as well as the fact that their recusal standards are self-policing, wouldn't you be sort of politicizing both their time on the bench and after? I'm just curious about your thoughts on that.
Twofold answer, thanks. One is that an 18-year term may well be long enough to allay the most serious concerns about the revolving door. That's a long term, 18 years. Indeed, it's longer than the state Supreme Court justices have by way of comparison. And other countries use similar terms for their highest court and seem to find that concern manageable. But the second and kind of better answer is that the way in which you reconcile the proposal with the guarantee of office during good behavior, the life tenure guarantee, although that term isn't used in the Constitution, is that you still get to be an Article III judge after 18 years. So the only thing that's time limited to 18 years is your service as an active justice on the Supreme Court. And under different proposals, either you become an inactive justice after 18 years, or you could serve on a circuit court under other proposals. But I think all the proposals I know of, so as to allay the good behavior clause constitutional concern, let you still be an Article III judge past 18 years, and therefore deal with the revolving door concern as well.
Any other comments from the panelists? And I think we have time for one more question. Any other comments on that point from the panelists?
I mean, Praveen, I think
Please.
you raise an important point, because ethics and a growing concern that judges are perhaps not dispassionately applying the law, but instead are thinking about their sponsors who got them there. I think there is a growing ethics concern with the existing Supreme Court without even having them be able to leave and go work either for a company or a firm. So I think it's a good concern I hadn't heard raised before to the term limit idea.
Yes.
So I'm curious what your thoughts are about Chief Justice Roberts recommending an investigation on some allegations on Justice Kavanaugh a week after he was confirmed. Have you heard anything about what happened with the 10th Circuit and those allegations that have been requested to be researched, investigated?
So my understanding of the law is that no lower court judge could punish or enact any sort of findings against a sitting Supreme Court justice. So I think the timing of the referral may of itself, mean it's going to a dead letter office. It's not, as far as I know, it's not something that Judge Timkovich would have any ability to discipline or investigate a sitting superior of his, which is one of the 9 Supreme Court justices.
Supreme Court justices aren't covered by the Act. That's the point. The Act defines judges in such a way that it doesn't include Supreme Court justices. Now, got transferred under the statute to the 10th Circuit. I was wondering myself why we haven't seen anything yet, because I think it's an open and shut case. But then I recalled that the Judicial Conduct Committee of the Judicial Conference has to pass on decisions of the circuit court judge, just as a matter of routine for reasons we don't have to go into. And I imagine that's the process that's going on now. But I think the day's going to come pretty soon in which the chief judge of the 10th Circuit simply concludes the proceedings because they have no jurisdiction over now Justice Kavanaugh.
And I'll just add that I do think there are going to be things that come to light that senators would have factored into their decisions, but because Brett Kavanaugh's record as a public operative in the Bush White House was deliberately hidden, senators didn't have it in front of them. So I think your question goes to the timing and possibly suspiciousness of the delay of referring that. And I have no idea what the charges are in those allegations, but I can absolutely see that with more FOIAs and with the Presidential Records Act time expiring, there will be more publication of the record that should have been in front of the Senate before it voted on the confirmation of Brett Kavanaugh.
Kristine, can I put you on the spot and ask what you think of proposals in this spirit of Democrats that the House should, in the coming 2 years, investigate various aspects of the Kavanaugh allegations against him, or do you think that'd be a bad idea?
So I have a concern as a general matter about judicial oversight by the House Judiciary Committee because of some memories of what happened in the early 2000s where judges were called in front of the committee to talk about why they departed sentencing-wise. So I come to it with some reluctance of oversight of the third branch, but in this instance, there were some real concerns about process, what the FBI was restricted in terms of its investigation. And also, you know, there were some other very serious allegations that will, I think, unfortunately lead to people having lower public faith in the Supreme Court. So I think that oversight of the third branch needs to be carefully done, not how it was done 18 years ago. But I do think that there are a lot of unresolved questions for one of the 9 most powerful people in the country, and I do think that there will be some oversight of it.
I decided I'd look in your direction. You have anything to say to that? I mean, you don't have to.
No, I mean, I think there are a lot of open questions about the whole Kavanaugh affair. Sometimes when I talk about the process of judicial nominations, I pause to talk about one thing that works really well, or relatively well in my experience, is this background investigation process. When I was on the Hill, I worked daily with Kristine's colleagues in Senator Leahy's office on reviewing the backgrounds of nominations, and I thought we did a pretty thorough job. It was never politicized. Nothing ever leaked. My colleagues in Senator Leahy's office knew embarrassing details about the private lives of prominent Republicans and never told the press. I mean, it worked really well. Something went wrong in this process, and I want to know what, and I think the Senate needs to figure it out because it needs to work in the future. The solution to this stuff spilling out in public is a White House stopping to share the FBI files on nominees, which would hurt the process even further. So I hope they work that out, and I hope they correct that. It's a separate bucket of issues, but I think the background review is really, really important, and it needs to be professional, it needs to be bipartisan.
Well, with that, I'm going to conclude the panel. I want to thank the panelists. It was a conversation marked to a refreshing degree by civility and thoughtfulness. I'm heading back to D.C. where I will not be exposed anymore to that behavior. So I thank you very much, all of you, for coming.
Thank you.